Assalamualaikum and hi, we are from Group 5. We are going to present about our case review. So the case citation is Dr. Wong, Chuen, Yeen versus Thivagar, anak lelaki Bala Ratnam, and another case to 2023 MLZU 584. So the parties involved, which is the appellant, was the Dr. Wong, and the respondent was Thivagar, anak lelaki Bala Ratnam, who is the patient of the doctor. So this case was an appeal case from the Session Court and was heard in High Court of Kuala Lumpur. So the judge for this case was Rose Mawar Rosain JC. So we move on with the facts of the case. So in Session Court, the plaintiff claimed that the defendant had committed medical negligence, which the defendant failed to provide enough knowledge to the plaintiff about the side effect of the treatment given to him. So the plaintiff also claimed that the defendant did not have enough knowledge and experience of the condition of the plaintiff and had provide him with unnecessary medical treatment. So the plaintiff condition got worse after he received the treatment from the defendant, and he went to his family in Ipoh and was sent to Hospital Fatima to get the medical treatment there at Hospital Fatima. So the plaintiff sued the defendant for damages with interest, cost, and other relief deemed necessary by the court. So there are special damages that being claimed by the plaintiff, amounting of 177 and 64 ringgit Malaysia. However, the plaintiff did not bring any witness or experts from Hospital Fatima to help confirming his claim. So the defendant, on the other hand, had also brought out some experts, because in this case, the defendant also appealed that his action for not advising the plaintiff about the risk that not usually happen is a common practice in the doctor's industry. There are two legal issues that we found. So the first one is whether the medical treatment administered by the defendant was the effective cause of the medical condition that the plaintiff suffered later. And the second legal issue was whether the defendant was negligent for failing to advise the plaintiff of the rare risk of receiving the medical treatment.
So for the counsel's argument, we are going to hear from both parties. First, from the plaintiff's counsel, they argued that the last two paragraph 69 and 70 of the grounds of judgment are contradictory, where the plaintiff's counsel pointed out that the Session Court found that the defendant was negligent for failing to inform the plaintiff about the effects of the medication, but also found that the plaintiff failed to prove that the defendant's negligence caused the plaintiff injury. Second, the plaintiff's counsel insisted that the defendant mixed medication with normal sleep and administered it to the plaintiff. However, a close scrutiny of the evidence in the appeal records shows that this allegation may not be supported by facts. That is from the plaintiff's side. Now from the defendant's side, firstly, the defendant's counsel argued that the medical treatment didn't cause the plaintiff to suffer the said medical conditions, and there was no evidence from the expert that stated it was accepted medical practice to advise on such a rare risk. Second, the defendant's counsel argued that the defendant didn't have a duty of care to advise the plaintiff to seek medical attention from a surgeon in a hospital. So the court found that the plaintiff had not shown how the advice to seek medical attention from a surgeon in a hospital was required to be imparted by the defendant.
Now let's move on to the court's decision. On the part of plaintiff appeal, the appeal was dismissed. The finding of the Session Court that the plaintiff had failed to prove its case of medical negligence is upheld as per the order of cost RM10,000 are upheld too. The cost of this appeal of RM10,000 is awarded to the defendant. On the part of defendant's appeal, the appeal was allowed. The court found that the defendant was not negligent or had breached his duty or had acted contrary to accepted medical practice, not advising the plaintiff of the very rare risk. The judgment of the Session Court that awarded global damages RM10,000 is set aside. Cost of RM10,000 being the cost of this appeal is awarded to the defendant. Next is court observation. On the part of plaintiff appeal, the court has observed that the doctors from Hospital Fatima who had attended to the plaintiff were not called to explain the medical condition of necrotizing fasciitis and a perforated appendix, which were later to have suffered by the plaintiff. And most pertinently, there was no clarification as to the cause of source of the said medical condition. The court found that the plaintiff had failed to adduce evidence to support its contention of negligence by the defendant. The court also finds that the submission by the plaintiff counsel that the contents were deemed admitted as they were referred to the defendant's expert untenable and acceptable. The Session Court found that the necrotizing fasciitis right arm occurred after the administration of the injection, not that it was because of the said injection. On the part of defendant's appeal, the court found that the Session Court was erroneous to have held that the risk should have been advised by the defendant and that the plaintiff may have not chosen for such medical treatment. The court also finds that it is incorrect to presuppose that the plaintiff would have refused the medical treatment with the knowledge of the rare risk. The court concludes that the risk, because it was very rare and not commonly conceivable, was not material enough to warrant an advice by the defendant before the medical treatment. The plaintiff had indeed failed to prove through any medical expert that imparting the advice of such a rare risk was accepted as proper by a responsible body of medical profession.
So, the rational descendant right of the case can be summarized as follows. First, in medical negligence cases, the evidential burden is high. The plaintiff bore the burden to firmly and specifically prove the negligence alleged against the defendant. So, the case considers the Bolam test for the standard of care in medical negligence cases, distinguishing between diagnosis and treatment in one hand and the duty to advise of risk on the other. For instance, to succeed in an action based on negligence, it is necessary to establish a breach of duty of care, and the degree of want of care which constitutes negligence must vary with the circumstances. In the case of a doctor, the true test for establishing negligence in diagnosis or treatment is whether he has been proved to be guilty of such failure, as no doctor of ordinary skill acting ordinary care would be guilty of. The standard of care expected of a medical practitioner is that he is not required to exercise the highest or very high standard, but only a fair and reasonable standard of care and skill in the treatment of his patients. Therefore, the plaintiff must prove that the defendant failed to discharge the standard of care, which is a fair and reasonable standard of care and skill in the treatment of the plaintiff. Next, the duty to advise of risk associated with the proposed treatment is determined by the courts rather than a body of respected medical practitioners. So this duty is based on the right of self-determination as established in the case of Rogers against Whitaker. So this indicates that the courts play a crucial role in deciding whether a patient has been properly advised of the risk associated with the proposed treatment. So the sessions judge is mindful of the legal position as decided in Dr. Ismail Abdullah by Azhar Mohammed Judge. However, the Court of Appeal critiques the session judge as he had failed to apply the principle seriously. So the Court of Appeal agrees that the sessions judge failed to follow this principle of only material risk and not minimal risk of injury arising out of the treatment or operation that need to be disclosed to the patient or the deceased.
We are going to discuss the objective dictum from our analyzation for this case. So the first one is about the treatment or diagnosis made by the defendant to the plaintiff. So in paragraph 32, the plaintiff had not informed the defendant what he had told the doctor before, Dr. Thivagar at Hospital Fatimah Ipoh, that he was in tremendous pain for 5 days prior. So there seemed to be no other evidence for the defendants to do the diagnosis and treatment otherwise. Therefore, defendant has done a correct diagnosis to the plaintiff with all the evidence provided at the moment. So it also mentioned in paragraph 45, which defendant was not negligent in administration of the injection, instead of giving the medicine orally given the plaintiff state and the condition at that time. Okay, factually, the plaintiff was relieved. Okay, the pain that he suffered was relieved and he felt better, and the plaintiff felt better after the treatment before he left the clinic. So after that, the plaintiff cannot bring or adduce any evidence to support his contention that the medical treatment at the moment was unnecessary because it actually cured the pain at the moment. Then we need to mention the essentiality of bringing expert to confirm the evidence made by the parties. So in paragraph 57, the High Court in this case have put into highlight the essential role of having medical expert to assist the court while making decision. So court cites the case of Pairmalu Verapan versus Dr. Amarjit Kaur and others, which held that the testimony of expert would have been the most material to the issue of causation. Nonetheless, the High Court states that the session courts, with regard to the non-marking of the plaintiff's regards from Hospital Fatimah Ipoh, was not erroneous.
Now we are on the last part of discussion, which is analysis. We will analyze regarding the decision of the court, the relevant cases that used in the court, and then the impact on the future cases. So, regarding the first decision, which is the plaintiff appeal, was dismissed. The plaintiff wanted to claim regarding the 10,000 ringgit of the medical negligence that was dismissed by the court. The plaintiff claimed that the defendant's action was the effective cause of the medical condition that was suffered later by the plaintiff. The court had found that the plaintiff had failed to adduce evidence to support its contention of negligence by the defendant, contrary to what was averred before the session court, that the plaintiff would be calling 6 witnesses, including expert witnesses. None were called. Nonetheless, an independent medical expert was not called by the plaintiff to help ascertain that the medical treatment administered by the defendant had caused the medical condition said to be suffered by the plaintiff later. So, we support the decision of the court because the plaintiff had failed to prove that any of the action of the defendant was the effective cause of the medical condition that suffered by the plaintiff later. And then the plaintiff had failed to bring any independent medical expert to help in the decision of the court. And then the court also stated that in medical negligence cases, the evidential burden is high. The plaintiff bore the burden to firmly and specifically prove the negligence alleged against the defendant. Therefore, the plaintiff had failed to prove that the defendant was discharged of the standard of care, which is a fair and reasonable standard of care and skill in the treatment of the plaintiff. The plaintiff had failed to prove that as a result of the defendant's failure in discharging the said fair and reasonable standard of care, it caused him to suffer the medical condition. And based on the Bala test, there were need in the medical expertise to help in the several medical opinion, medical view. However, the plaintiff does not bring any expertise to help him regarding the medical condition that cannot prove that any of the defendant's action was the effective cause of the medical condition that suffered later by the plaintiff. And then the court also found that the medical condition or the right arm of the plaintiff was occurred after the administration of the medical treatment by the defendant. Not it was because of the medical treatment, not it was because of the injection. Next is the second decision of the court, which is the defendant's appeal. The defendant's appeal was allowed. The defendant appealed regarding that he was not negligent for failing to advise to the plaintiff of the rare risk of reserving the medical treatment. So, the court had found that the defendant was not negligent or had breached his duty or had acted contrary to accepted medical practice by not advising the plaintiff of the very rare risk of the occurrence of neutropenia or necrotizing facilities. So, the court found that the plaintiff had indeed failed to prove through any medical expert that imparting the advice of such a rare risk was accepted as proper by a responsible body of the medical profession. The plaintiff had to fail to show that the defendant had acted not as expected of a competent medical practitioner. This decision also looked through in the case of Dr. Kuah Ting Sai versus Manomni Sabramani and another. So, from the medical expertise that brought by the defendant, his evidence was that based on the facts of the case, it was his opinion that the defendant was not negligent and that it was impossible for him to have had anticipated the occurrence of necrotizing fasciitis, as it was not even a remote possibility that a medical practitioner could have reasonably been expected to consider. So, we support this decision of the court because the plaintiff had indeed failed to prove through any medical expert, and then the plaintiff had to fail to show that the defendant had acted not as expected of a competent medical practitioner. And then the defendant brought the medical expertise regarding about the advice of the rare risk, and then based on the medical opinion on his view that the defendant was not negligent because as he stated that it was not even a remote possibility that a medical practitioner could have reasonably been expected to consider regarding the occurrence of necrotizing fasciitis, because it was such a rare risk that even a reasonable and fair and a competent medical practitioner to consider regarding the rare risk if they have the same case have occurred. So the court also should have a critique regarding the decision by the session court, as they had failed to use of the case, had mistakenly to use the Rogers versus Whittaker to rightfully to apply of the principle, which is emphasize the court's role in determining the adequacy of advice regarding the treatment risk, because the court's role had such a big role in the duty to advise of risk associated with the proposed treatment. Lastly, the impact on the future cases. First, future cases can use this case as a precedent regarding the issue of the case about medical negligence. Second, the importance of medical expertise in court to help a certain issue that need the medical opinion. The other courts will notice about the importance of medical expertise, the use of medical expertise in the court. Third, other lower courts will be more careful on deciding a case by using the correct implication of a principle. Fourth, the importance of the evidential burden on medical negligence case that required to prove by the plaintiff was heavy. That's why the other courts can use this case to be noticed regarding the importance of the responsible of the evidential burden on medical negligence that the plaintiff need to prove.